Okay. Go.
You hand me my screen box. Now go. Freak.
All right, this is the City of Taylor versus Josine Harbaugh. It looks like we have 1, 2, 3 civil infractions up today.
Yes, Your Honor. Good afternoon, Your Honor. For the record, MrzFieldzYT for the people.
Ms. Harbaugh, can you turn on your camera and tell me your name?
Oh, I thought my camera was on. Hang on. Sorry.
It's okay. Can you tell me your name?
Josine Harbaugh.
All right, Mr. Zick.
Your Honor, today is the date and time set for a pretrial on a certificate of compliance second offense ticket. These are regarding the property at 5945 Marvin. The other 2 tickets, one is from 2022, the other is from 2023. Those are both in default, Your Honor, is my understanding. Both of those are set for show cause today. Each of those tickets, the 22 and 23 tickets, have a balance of $247.
All right, I see that to be true. As with respect to 241659 or 495, what are we doing on that matter?
So that's a certificate of compliance second offense. We're respectfully requesting a 30-day adjournment to allow Ms. Harbaugh to pursue going through the process to obtain a certificate of compliance, but that's the only matter we pre-tried. The other matters leaving to the discretion of the court, as those are show cause hearings on default tickets.
All right, well, on those other 2 matters, Ms. Harbaugh, it looks like you owe $247 on these 2 tickets that are in default. One's been in default since early 23 and the other one since mid 23. And it's essentially $500 that are owed. $494. Do you need a payment plan on those, ma'am?
No, ma'am. I need. I really think that I shouldn't have to pay those because I wasn't notified. The house has been vacant for years. I've been getting letters from the city since 2019 on this home. I actually let my in-laws stay there starting last summer. They came in from Florida. My father-in-law has dementia while we're finishing up some work that we need to do on the home. I can't explain, and I couldn't on the 24th when I spoke to, I just said her name. I explained to, I don't have her name. I think I just said it was Marcia.
We have Marcia here.
That, there are some, like every time we've received notice on this house, I've called. The home was vacant. I can't help if I didn't receive something.
Well, the notice was sent to your address in New Boston.
I understand that. And as I explained to Marcia, we live in the country. I don't know if we didn't receive, as you can tell, there's a history. Every time I receive something, I make sure that I call. But if I can't respond to something that I don't have.
This one went out to that address as well. The letter from the 23rd District Court, we've got something that went out.
Does it come certified?
No, we don't have a responsibility to send things certified mail. Are you getting all of your other mail, Ms. Harbaugh? Are you getting all of your other mail? Or do you get no?
Yes, ma'am. I am getting all of my mail. And as you can see from the notes that are in your computer, I have responded every time we have received any notification.
This particular case, I have that the show cause order was mailed out on November 6th of 2023 to the address on West Road. On 10/4 of 2023, we sent out an overdue payment notice. On another notice was sent. What's the date of this one? on January 25th. So that one got to you because you came today. I don't have any notes on the register of action.
Maybe I'm getting confused with which ones I'm being charged on then.
Yeah,
because
I mean, I don't have anything on these that show, I see this was sent out again. Like, I understand if the ticket is left or, you know, but I see that we're sending out notices consistently.
Yes, and
February 27th of 2023, the ticket looks like it was sent to that address. We sent out court notice on March 7th of 2023 to that address, November 6th of 2023. I mean, like, each of these tickets has multiple mailings on them.
No, I agree. I'm just saying, if you look, this has been going on since 2019. And the home,
I don't have anything. I don't have anything except for a 2022 ticket, a 2023 ticket, and a 2024 ticket. And the 2024 we're adjourning out for 30 days. But the other two tickets are in default.
What, can you tell me which two though? Because I guess I'm confused because
Ticket numbers are this: 231-59158 and 22157540.
Okay. The 57540 is the one that I don't have any record of.
But the 2023 one you do?
That's the one that was set for 124 when I spoke to Marcia, correct?
But yeah, it looks like a virtual proceeding was held. So yeah, so you must have talked to Marcia.
Yes, I did. Yes.
And then it was set for a show cause today.
Correct. And when I was on the Zoom meeting with her, she informed me that there was another ticket coming from January the 12th, which we hadn't received yet.
Yeah, that's the one that you're here on today. That's the third ticket. The January 12th one is the one that Mr. Zick is asking for a 30-day adjournment so you can obtain a certificate of compliance on.
Okay, so the one that I'm disputing is the 157540. I have received and responded to every other one that we were sent. That's what I'm saying. That one I never got. And if you can look back through, I mean, I have responded to every one. And you're talking $500 plus now an inspection fee on top of that. I didn't purposely disregard or disrespect the court. I just never received it. And as soon as I didn't get a ticket or anything. I just got the motion and affidavit to appear on 124, which I did. And then she informed me, Marcia did on that date, which I hadn't received yet, that there was another ticket coming for a vehicle.
But you did, but when you normally see Marcia, Miss Gilmer's our collections clerk. So if you'd have met with Miss Gilmer, it was basically a show cause to get you to make some sort of payment towards the balance on these tickets, because it's just tickets. It's money that you owe. A lot of it is late fees and other fees at this point. I mean, because of how long these tickets are, but whatever happened with you and Miss Gilmer, no, a payment was never made.
Correct. Yeah. Because when I spoke to her, she said, I am disputing these because I wasn't notified. Again, I didn't know exactly which ones we were talking about because I have communications going back to 2019. And she said that if I hadn't heard anything, she gave me your clerk's number to call because I should receive something in 2 weeks, which I have, and that's consequently what we're doing today. But I didn't know that I
And if you want to file, if there's a form you can fill out if you want to set aside default judgments. But the problem is these tickets there's no you can't, I mean, we're past the point of you just saying, I didn't get notice. I've looked through the files. There are multiple notices of it that have been sent out on both of these tickets. There are multiple court notices that have been sent out on both of the two old files that are in default.
Right.
So if you want to dispute them, your only remedy, to be honest with you, is to try and file a motion to set aside the defaults. And if you file something, I'll consider it at that time.
Yeah, Your Honor, the only
But
thing
otherwise, you have to make payment.
the only thing I'm disputing is the one from December of 22 because I never received anything. The paperwork that I
Look, if you want to set aside the default, you can file a motion to set aside a default. I mean, that's up to you. I'm just gonna say, adjourn 30. So we go here on that, on the other case. So, defendant can, file motion to set aside.
Your Honor, don't even worry about it. I'm just gonna pay the fines. Hopefully I'll not get harassed anymore.
You're not, ma'am, getting tickets or listen, this is a courtroom. You don't have to like it. I get that, but that's fine. That's fine. You don't have to.
I know.
But you're not going to be disrespectful in a courtroom. I've let you say your piece. I've heard you. I've looked through the files. I see that multiple notices were filed. So if you want to, I'm going to give you a 30-day adjournment on the ticket from January 12th of 2024. We're just putting them all together. So the ticket from December 6th of 22, the one ending in 157540, I'm adjourning for 30 days. If you want to file a motion to set aside, that is fine. And with respect to the ticket that you're not disputing, ending in 159158, you have a payment plan of $50 a month. And you'll get notice of that new court date in the mail. If you don't receive a court notice within the next 2 weeks, you should call the court because I'm telling you, the notice is going out in the mail.
All right, thank you.
You're welcome. We're all set.
23-41304 is now called. You are Yolanda Martin.
Yes.
John West is here representing you. And this is a theft case, state jail felony and theft. And why we're here, you tested positive for cocaine on a drug patch that was collected on January 17th, and it was analyzed, and that violates your terms of bond. You shall not stand by. I see another one. Yes, that was collected back in October. That was positive as well for cocaine. Then there was another one that was, October 12th, October 25th, collected positive for cocaine. And then we have another one, this most recent one here, January 17th, collected, and it tests positive a third time.
That's probably
Okay. Can you explain those?
Your Honor, she had, and I'll let her speak a little bit too, but she's talked to me quite a bit. I think that was the first a drug patch issue. You revoked the bond and she would make bond again and got out back again. She has gone to recovery, to rehab. She's cleaned up. She has been adamant that she has not been using since that first drug patch issue back then, that she stayed clean. She's made every effort to stay clean. We are unsure why it's tested positive.
Maybe it's because she has cocaine in her system.
It maybe not cleared out, but it should have cleared out by now. I don't know. We would, if there's any chance, Your Honor, the court would be willing to test her and do an on-the-spot test.
What difference would it make?
Well,
What was it? She's failed the tests.
but it was
Another test. She can't purge past tests.
Well, if she's dirty today, then we would have any argument, and then we just have to deal with it. But she's adamant that she's clean, and she has no idea what is causing this to come up dirty.
You're relying on her word, and I'm just looking at the indictment with her 16 prior theft convictions. her word's not worth much unless it's validated and supported by some corroborating material. 16 convictions, and she's charged with a theft, and that's why we are here. A felony, when you steal a pack of gum, it's a felony because of your rich history of theft convictions. But thefts are used in evidence to show character issues like dishonesty. And your word is not good enough. I'm going to rely on science, on the drug patch. What else?
Is she speaking out? But
I have not used it since.
Your word.
I
That's what
understand
you
what
say.
you're saying, but I haven't used since March the 16th of 2023. That's the last time I used. I've been doing everything I'm supposed to do. The people at the patch company said if somebody touched me or anything, might get on my system. I do ride the city bus. I have gotten a job. I work every day. I go to work at 8 o'clock in the morning. Every day I have got a job and I've been doing everything. I don't even go nowhere. I stay at home. Only thing I do is catch the city bus, maybe touching somebody's doorknob or shaking somebody's hand. But other than that, I have not put a drug in my system.
I'm sorry, your word's just not good enough when you have a rich conviction history of thefts, which are used in the rules of evidence as evidence for character and truthfulness. Sorry, I have to rely on something like the science. And this is the third positive while on bond. And I'm either going to rely on this or not. Your word, I'm sorry, your word is not worthy. You have proven this since 1992. What is her bond?
I believe it's.
What is it now?
It's 40,000 now.
It's doubled to $80,000. And she will continue to have a drug patch as a condition of bond. That is all. You're taken into custody. Thank you, ma'am. All right, go ahead. Let's go on Wilkerson. Mr. Wilkerson. David Tovar.
Yes, sir.
Where's he? Yeah, we got to bring him out, please. And
Just courthouse motion, a written motion, this bond, or is this just brought up oral? Because I looked for one and I could not.
Here's a copy of one,
But it's like one for this particular one, not a previous hearing, but that's what we're going.
the second motion is what we're
This is filed
in August of 23.
23.
Yes, sir.
This is, we're going on the August 23 motion.
Yes.
and this is a follow-up from what?
That's my question.
No, it's a follow-up from,
What ruling was made then
yeah.
that we're continuing?
At the time that this motion was made,
What
there had
motion?
been records that hadn't been produced to us, which is still the case with regard to the medical. And I believe the statement from the court at that time was somebody could walk over and get those today. This is when you were first coming onto this case and Sonny was discussing it, and we discussed the facts.
I came on in October, 2 months before I was here.
So, and at that time,
You're asking for relief on bond, right?
yeah, sure.
All right. I don't even have any, I don't know when the matters occurred. I don't have any writing on the outside, which which bothers this court. I don't know when these decisions were made. There was a second motion in August 21st of 23 that was filed. And I guess that's what you're talking about.
Yes.
And you want to, but we had a hearing on that and I made rulings on it, correct?
No, Your Honor, we've never had a full hearing on it.
Have we had a hearing? When was the last time we had a hearing on this? Does your records show?
The last time there was a decision made on a bond,
We're talking about a hearing on the matter. whether or not a decision was made. When was the last time we had a hearing?
My records don't indicate.
Mine don't either.
The state file doesn't indicate that
This,
there was anything. The only thing the state file indicates is the 2022, December 22.
I mean, I'm prepared to proceed with it as though this.
are you ready?
We can go forward.
Are you ready or not?
I'm ready. Whatever it is. I just want to make sure what we're doing. That's
Well,
I look forward to try to decipher where we were. Like if we're reopening a hearing that's already started, if this is just a continuous bond thing we're going to do off one motion that's filed 3 years ago, that's my question, Justin. Where are we procedurally with this?
question really I have is what prompted this hearing for today? For this matter to be placed on today? I'm really not sure. Because I don't see anything that prompts it.
It was a discussion at a previous trial setting, judge, and the court said, well, that the court would be willing to consider some circumstances surrounding the outcry to set a hearing on it. And so that's what we.
Okay. Are you ready for that?
I want to be clear though, first of all, what prompted this hearing is that I believe it was 2 weeks ago, we were set on this vote where counsel wasn't available for medical reasons.
Right.
But state was here for it, and the witnesses, obviously, the family was here, and then it got reset. So I want to remind us of that. I don't know what that was. We were ready then, we're ready now. But I just want to make sure it's clear.
Well, I mean, if you need to respond, do you have witnesses available today to respond?
There's not Judge, I don't know that's my point of this. I'm not sure what we're here to do other than discuss 1715.
What do you intend to do?
I intend to put on the mother of the victim to discuss the fact that there was an external hymen present, that the loss of her virginity coincided with an entry in her journal. I further intend to argue the fact that the state still has to produce the records from Spindletop, and is also saying that the announcement when it was numbered was not ready, and then you said, but you're ready aside from wanting the other case to go first. That's even if the court doesn't reduce the bond today, we need to address that issue because it would be manifestly unjust for my client to remain in jail while a case that is newer with the same complaining witness was tried to the court. So I believe that my client is entitled to a bond based on the fact that the remaining medical records have not been presented to us as they were supposed to have been some time ago.
What about that?
Judge, it's the first I've heard of a discovery issue.
Here's what we're going to do.
This is what this is.
No, here's what we're going to do. I'm going to ask you to do this, Mr. Wilkerson, because I don't like the way it's been impromptu addressed orally, and the state's bewildered. Put this in writing so it can be. Is this bothersome for you? Put this in, articulate your needs as soon as possible. Put them in writing so we can memorialize it, so everybody can be on notice on what the hearing is. I don't know what this is either. It's just an open kind of a thing. And I know it is prompted by the Court of Appeals decision on him that was just released. So, yeah, great, let's get this. I'll be having hearings every morning before we go into the trial in the next 3 weeks. And we can put that in there. I want to see in writing what you're talking about because I'm not following you at all. And he gets a fair notice of what is needed. Do you understand? Can you do that and get that as soon as possible? You get it, file it. I will set it within a few days. Do you understand?
Your Honor, number 6 and number 8 from the second motion address specifically what I intend to address today. Number 6 and 8 from the second motion was filed back in August.
Okay. What are you ready for that?
Judge, I'm not because I don't. That's our
When
first
can you be
question.
ready?
Whenever I mean, we will get it as quickly as we can. 2 weeks.
What is that?
2 weeks. Give us 2 weeks so I can
You got to wait.
keep that moving. A week's fine. I'll figure what out.
They're not ready.
We're not ready to decipher what we're doing.
And truly, you're telling me right now at 9:45 what the particulars are that you want to deal with in this hearing. You got to tip us off a little better than that, especially in light, they got a different prosecutor here.
Yes, Your Honor, and respectfully, it was the first time that this motion was discussed. The transition was taking place. Sonny was here. It was when Mr. Hoppower was first coming into the case, and it was it was in consideration of the second motion, and the court said set a hearing on it. So ultimately, that is what we did, and be absent for medical reasons. The state was ready to proceed based on this motion, but today the state's not ready to proceed based on this motion. So I feel like the motion clearly articulates what I'm here to present.
If I can respond to it,
Yeah.
let me be clear. The state was ready, but to ask the questions I'm asking today, what exactly are we?
Y'all need to, here's what I would suggest. Since I've practiced law a lot longer than both of you,
Yes.
I've never been in a situation where people are not communicating with each other and filling in the blanks. Either side is not clairvoyant. Y'all got to give each other, in all professional courtesies, a heads up of what the plan is. Not, it's going to be a bond here. Okay. I say, okay, fine. But that's a global statement. It's not fair to either side what the parameters, or we could be here for months, years. And I don't like that in light of this, my trial docket, my overall docket, and often lately, that's what's happening. People are coming in and surprising each other. I never grew up with that in the practice of law. It was always people knew heads up what the plan was. They talked to each other about this is what we're going to be doing. What do you have for me so that we don't waste everybody's time when we get here like we're doing? And there's not the professional congeniality that I'm used to. Y'all need to communicate. You're in the business of communicating. And I don't like hearing, I'm not sure what this is. I don't know what it is either. And I don't find that you are communicating with each other so that we can come up here and save time so that the hearing on the merits can be held and not antics like I'm performing on why is someone up here surprised? And there should be no surprises up here. There should be nothing about ambush of information. Get it done. You got 1 week. All right. And get this man's constitutional rights dealt with, but inform each other. This is not just an open door to go, we're going to do a bond hearing. There is no limit to that. What do you have to say?
Respectfully, Your Honor, again, this particular motion was brought up to the court when Mr. Hoppower was first taking over this case.
Are you denying that?
I did not just.
See,
Didn't come over to
see,
doc.
this is not what I like to hear between professionals. Work this thing out. You got 1 week. You're going to get this man back up here on Wednesday. Can we do it on Wednesday?
Yes, sir.
Wednesday morning. Y'all be ready.
Yes.
So we can move through this. Does everybody understand?
Yes.
Sorry for the delay, sir.
Thank you.
All right. Don't communicate. You're in the business of communicating. Thank you. Okay. It's only constitutional rights at issue. This is important.
Are you kidding me? Oh my God. You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself something.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, let's bring people in. People are going to learn how to act in a courtroom. Can you hear it? Can you hear it? Man? Man? Can you hear it? Okay. I have no patience for that. But trust me, at the end of the day, I'm sitting up here, I'm the one that needs a drink.